against Pennant and another.
Yes, Mr. Guthrie.
Yes, my lords, in this appeal I appear on behalf of the appellant, Mr. Almazeedi. The liquidators are represented by my learned friends, Mr. Francis Tregear and Mr. Matthew Gook. My lords, I make the usual assumption that you have had the opportunity to look at the papers and that I needn't open the facts in any detail.
More than opportunity is the correct assumption.
Well...
opportunity doesn't help you very much.
Well, Lord, I should have added that I know that you will have taken that opportunity. Lord, there is a short first matter concerning the relevant law. We're agreed, I think, as to the relevant test set out in Porter and McGill, but I think it's important that I should make the appellant's position clear as a matter of principle. Your lordships will have seen the respondent's written case.
Yes.
Can I ask you to look at paragraph 4 of that, which, for those of you tied to the electronic version, it's at page 1646, if that helps. The respondents say in that paragraph, this appeal concerns the doctrine of apparent bias. It is not argued that the judge lacked independence and impartiality, which they say is clear from our written case.
Yes.
My Lord, as I say, it's important to avoid any misunderstanding, and I also ought to make it clear at the start that there is no allegation in this case of actual or conscious bias on behalf of the judge. But the appellant continues to argue, and indeed has argued throughout in the Court of Appeal, that the circumstances are such that the doctrine of apparent bias applies and means that the tribunal cannot be regarded as independent and impartial. That is the way in which the doctrine of apparent bias works. And, my lords, this is the way in which it was understood, as we say correctly, by the Court of Appeal of the Cayman Islands. And can I take your lordships in support of that to their judgment, which your lordships will find in bundle 1A, and the electronic reference is page 3.
This is the joint bundle of authorities?
No, this is the judgment of the Court of Appeal in the Cayman Islands. In this case, in other words, the judgment from which the appeal is brought. It's in bundle 1A. It begins at page 2, but the passage that I wanted to refer to is at page 3. And it's at the very foot of page 3, where the judgment being delivered by Sir Bernard Ricks reads, "This is the area of the doctrine of what in the English common law is called apparent bias. Apparent bias may not be the best term for what is really a question of lack of independence, but that is a matter of semantics. It is not alleged that the judge was actually biased." My Lord, again, if you go on in that judgment to page 20.
The whole basis of the doctrine of apparent bias is that it's almost impossible to prove actual bias.
Yes.
You can't go into that,
Yes.
and it's a pragmatic
Yes.
test, therefore, which
Yes.
caters for what a reasonable observer might think.
Well, my Lord, if what my learned friend says in paragraph 4 of his written case were right, then that would not be the position, but it is.
Mr. Guthrie, I think they are founding themselves on paragraph 80 of the judgment, where
Yes.
the court does seem to equate the concept of lack of independence and impartiality with actual bias. But you pointed out that that is really quite inconsistent with what it said at 5.
Yes.
And so, for the time being, let us not be confused
Yes.
by the way it was put in 80.
Yes, well, my Lord, you have actually lit on a small paragraph of my notes, which I was going to return to later on,
very
as
well.
to the inconsistency between those paragraphs. But the fact is the Court of Appeal did, as a matter of fact, apply the doctrine exactly as we understood it should be applied, which is apparent from page 20 in paragraph 61, where the Court of Appeal refers to a case which my Lord Manson and Lord Hughes were involved in. My Lord Hughes delivered the judgment. It's a case called Yaqub. I will come back to that. But in the paragraph of the judgment, this restatement does the great service of emphasizing the matter from the point of view of the positive values of independence and impartiality, rather from the opposite viewpoint of the negative quality of bias, which immediately has to be qualified by the epithet actual or apparent. Long before any question should arise of bias, what is important is that there should be no legitimate doubt about the independence and impartiality of a judge or tribunal. And in this respect, independence is as important as impartiality. A judge may be of the utmost integrity, but if he or she lacks independence, then there is a danger of the unconscious effect of that situation, which is impossible to calibrate or evidence. That is why so many expositions of the principles speak of the importance of the appearance of things and the demand that justice need not only be done, but be seen to be done.
Is he right about the unconscious effect? Or rather, the danger of the unconscious effect?
Yes.
Yes. So there has to be some risk of unconscious effect. Does it?
Well, not necessarily. No, not if the question is one of lack of independence.
Well, they're linked, aren't they? At least,
they are linked.
At least in Sir Bernard's judgment. Anyway,
Yes.
We may have to look at that
Yes.
further down the line.
Yes. There's one other point at page 31, my Lord, which may, to some extent, be in your Lordship's mind. In paragraph 93, when they're dealing with the appointment of His Excellency, Mr. Almazeedi, they say in the middle of, beginning at when this litigation commenced, etc., Mr. Almazeedi was not Minister of Finance. Then a little further down.
Sorry, Mr. Guthrie, paragraph?
Paragraph 93.
Thank you very much.
In the middle of that paragraph, from that time, the fair-minded and informed observer, knowing of the role of Mr. Almazeedi and of the conduct of QIA's legal counsel, already evidence in the case, would, we conclude, consider that there was a danger that the judge's independence and impartiality were compromised, and in that sense, there was a danger of bias. In other words, the fair-minded and informed observer would conclude that the judge should not continue in his role, that surely cannot be right, see Yaqub and the Queen, or that this is not how things are usually done, see Prince Geoffrey at paragraph 40, Belize Bank.
That does surely refer danger of bias there, danger that unconsciously the judge may be influenced by his connections.
Yes. Well, the question of apparent bias, unconscious effect of bias and independence are interlinked. I mean, they can't be separated. But there is, and we'll see in due course in the cases, a difference between a judge who may get everything absolutely right and so forth, but if he's actually subject to a risk of he doesn't have security of tenure, etc., then that of itself.
Yes, there's no use, I suppose, rerunning actual judicial decisions which involve weighing of competing factors and so on. But what we may be coming to at some point is whether it's relevant if there is no judicial decision in that sense. There is an entirely formal decision which doesn't, where there is no scope for movement.
Well, we will be coming to that, but in this case, the facts don't bear that out as a premise. So I will be dealing with that on that basis.
In Millar and Dixon, was there actual discussion of this particular point that my Lord and the Chair has raised, namely the implications of the fact that the defendant had pleaded guilty?
Yes. I will take you to Miller and Dixon, but if I could do so, I know I've given myself quite a generous estimate of an hour and 45 minutes, but I'm anxious that...
Well, we'll allow you to develop your answer.
Well, my Lord, we will appreciate from your reading that the appeal has two parts, effectively.
We can go one way or the other on your respective cases.
I didn't quite mean that. What I meant was that there are two distinct approaches from the appellant's point of view.
Yes.
And the first approach involves looking at the reasons given by the Court of Appeal insofar as they decided the matter in the appellant's favour. In other words, in the Court's view, the appointment of Mr. Almazeedi was a crucial matter, after which really there couldn't be any question but that the orders had to be set aside. My Lord, I won't read all the paragraphs, but the relevant passages in the judgment are in paragraphs 89 to 96. And those are in Bundle 1A at page 30 and thereafter. Lord, the 89 begins, the position changed when Mr. Almazeedi became Minister of Finance. They then set out what is uncontroversial, Mr. Almazeedi's, so to speak, deep involvement in the affairs of the various petitioning creditors, etc. And then in paragraph 90, they say it must be entirely exceptional, if not unique, for a senior government minister with power over the appointment and removal of judges to be involved personally in litigation being conducted overseas by a judge who is also a judge of a court, however distinguished, in the country where that minister exercises power. And they say that where a dispute with government is litigated in the national courts, it's inevitable that judges have to be trusted to conduct such litigation fairly and impartially. They're protected by constitutional safeguards which defend their independence. Those vary from country to country, etc. And then, my Lord, I've already looked at paragraph 93, and the judges conclude in paragraph 94 and thereafter that if the judge had disclosed his position, and the parties would have been in a good position to regulate the position, to bring it to the attention of the judge, the appointment of Mr. Almazeedi was publicly announced. We have no doubt that if it had been brought to his attention, he would have wished to recuse himself. It's not possible in this case to say, as it was in Prince Geoffrey's case, that interference in the Qatari judiciary was unknown, even if it is unknown in the case of the recently created commercial court, or that Mr. Almazeedi and the senior legal counsel played a significant role, but not shown a personal interest in the BTO disputes and litigation, including threats against opposing the interests of the Qatari state, or that the independence of the judges of the commercial court is protected in the same way and to the same degree as in Brunei or the Cayman Islands. In these circumstances, since it's the appearance of things that matter so much, we find ourselves driven to conclude that the orders of the judge should be set aside after the date of His Excellency Almazeedi's appointment. Lord, they regarded that as meaning, as a matter of fact, that the judge could not be regarded as an independent tribunal, and so they made the orders they did. Well, the point we make is that, in fact, the very principles which they were applying applied from the outset of the proceedings. They didn't only come into play when Mr. Almazeedi took over the appointment as Minister of Finance, and they applied as much to His Excellency Almazeedi's position, to his predecessor, His Excellency Mr. Kamal, as they did to His Excellency Mr. Almazeedi. Lord, if I can just digress for a moment. This case was heard in April of 2015, and it was some time before the judgment was delivered. I think it was April. Obviously there was a good deal of the usual exchanges between the court and the bar. However, this possible disposal of the appeal was not something which was canvassed in argument. I mean, there's no complaint about that. Obviously, it may not have been in the judges' minds themselves until they retired to consider the matter and so forth. But if it had been mentioned, it would have been possible to draw the court's attention to the fact that Mr. Almazeedi's appointment wasn't quite such a crucial event as they supposed. In order I can make that good, it will be necessary to look at the second volume, which is the record as such, I think, volume 2, agreed documents. Well, before I do so, can I just warn you that the page references, I hope there will be no difficulty about them, but if you are to compare the references to pages in my written case with the actual bundles, there may be a difference of 1 or 2 numbers. That's because the first bundles we filed had some illegible documents in them. They had all to be recopied and reproduced. And in that process, I think there may have been some slippage as to the accuracy of the references. But I hope that the ones I give you will be accurate.
Well, they're accurate for the electronic as well, are they?
Yes, well, certainly accurate for electronic. I can guarantee that, I think. The differences between the references which are given in my written case, as far as I know. But so I just say that. The question of Mr. Almazeedi, which was, as it was considered by the court, was really that he was a part of the sort of forces of Qatar, which my client considered were ranged against him. And if I can take you to the way in which he set the matter out in his first affidavit, and ask you to go to page 213 electronically, and I think you'll find that's volume 2, 213. That is his first affidavit in support of his appeal to the Court of Appeal. I begin at paragraph 7, if I may. I don't propose to recite the detailed history of the proceedings for the purpose of this application to the Court of Appeal. It was for leave to appeal out of time, of course. I ask the court to note that the petitioners, the QIA, that's the Investment Authority, and the Supreme Council for Economic Affairs and Investment are Qatari government agencies, as their name implies. In their investments in the company, the QIA and the Supreme Council had also acted as nominee for the Qatar Foundation and for Brugge Trading, an investment vehicle for the then ruler, the Emir of Qatar. The petition was supported by them and also by the National Bank, 50% owned subsidiary of the QIA. Ali Sharif Al-Emadi, the former Chief Executive Officer of Qatar National Bank, is the current Qatar Minister of Finance. He is also the chairman of the board of the Qatar National Bank, a board member of the QIA, head of the QIA Investment Committee, and chairman of the Qatar Financial Center Authority. He's also a business partner of Khaled Al-Mahari, the Chief Executive Officer of Evolvence Capital, the private placement agency firm that secured the company's investment commitments in 2003, totaling $290 million US, which have been in litigation since 2007. Qatari entities hold over 60% of the aggregate preference shares. It is therefore not an exaggeration to say that the litigation against the company and myself was instigated and controlled by entities of the Qatari government. The initial involvement of Deloitte to consider the company's situation and the proposed asset swap transaction, and the eventual appointment of partners of Deloitte as the liquidators was at the assistance of the petitioners. That's all I think I need to read at that point. Mr. Al-Emadi was mentioned in that context, and if one goes on to paragraph 39 at page 221, he's mentioned again. As appears from paragraph 8, this minister is closely involved with his proceedings. His name repeatedly appears in my evidence as a person who has acted against my interests and those of the company. Well, that is considered by the respondents by Mr. Penner, who was one of the liquidators, in his fourth affidavit. In the same bundle, if I can ask you to go to page 546, Lord, that's his fourth affidavit. It begins, for the record, at page 525, but at page 546, in paragraph 18, he deals with the appellant's allegations of alleged bias. I could say in passing, the first, second, and third affidavits were largely aimed at the extension of time and so forth. He says, a central plank of the appellant's case appears to be that certain of the company's preference holders, via their alleged links to the Qatari government or to ministers and or ministries forming part of the government, were capable of exerting influence over the Qatari judiciary. It is these apparent links which it's argued could lead to an apprehension of judicial bias on the part of the Honourable Justice Cresswell. In support of this assertion...
capable of exerting influence suggests that the complaint was that there would be positive interference by the Qatari government. It doesn't address the other possible problem, namely internal, subconscious internal influence on the part of the judge.
Well, my Lord, for a long time we would say, with the greatest respect to my learned friends, to the liquidators, they didn't really grapple with what was the real point of the case. That's really not a very helpful comment, I suppose. But at this point, they are dealing with the facts which Mr. Almazeedi was alleging. In support of this assertion, at paragraphs 8 to 9, which I've just read you, the appellant refers to His Excellency Mr. Al-Ahmadi's role as the Qatari Minister of Finance and his previous role as the CEO of the bank. Goes on to state, it's not an exaggeration to say the litigation against the company and myself was instigated and controlled by entities of the Qatari government. Paragraph 39, he refers to the Minister of Finance's role. And in paragraph 21, it says, while it's not for me to express a view on matters pertaining to the affairs of the Qatari state, I do observe that the appellant's assertion that the petition, which was unopposed, arose as a result of some form of conspiracy on the part or involving members of the Qatari government, seems entirely speculative and uncorroborated by any evidence. The appellant's characterization of Mr. Al-Ahmadi as one of the architects of the company's demise, who at all material times held a position of influence within the Qatari government, is not supported by the facts. Well, Mr. Almazeedi answered this in his third affidavit. That begins at page 681, but the relevant passage starts at 689, and it's perhaps just convenient to say that the context of this begins by considering the events which immediately preceded the winding up order, because I think in answer to a query raised by my Lord Sumption, the fact is that this case did not begin with the order of the judge making the winding up order. It began with the consideration of the petition, the appellant's
to validate.
the application to validate a particular transaction. And details of that transaction begin in paragraph 35. I don't want to read it all, but page 689, paragraph 35. When these proceedings were begun in the Cayman Islands, what the appellant wanted to do was avoid a winding up order being made, to which end he said that transactions which were well advanced ought to be completed, and that would avoid the need for the liquidation. And the judge, well, we'll see what happened in due course, but that was not a purely administrative exercise on the part of the judge. He was asked to consider that. And you'll see that what he said was, having described what the nature of the asset swap transaction involved, at paragraphs 35 and 36, he says in 37, I believe that the asset swap transaction was challenged by the petitioners, although it was in the company's best interest, because of a long-standing dispute between certain executives of the Qatari government agencies and myself. This was detailed in my 8th affidavit. I can now briefly summarize it. The executives concerned were connected to evolvents, etc. As a result, the manager and the company had brought proceedings in the Grand Court that had extended to the United States, this is paragraph 38, was likely to expose the executives of the Qatari government agencies to potential sanctions for breach of the US Foreign Corrupt Practices Act, FCPA, in formal memoranda submitted by me to the boards of the QNB and Qatar Holdings, affiliates of QIA. I had made their participation in such transactions clear. Copies of these memoranda were attached to my 8th affidavit. In short, I had blown the whistle on the corrupt practice of certain of the top executives of the Qatari government agencies. Then at paragraph 40, at the center of the dispute was Mr. Ali Sharif Al-Ahmadi, the then chief executive of the bank, currently the Qatari Minister of Finance, under whose authority the Qatar International Court Dispute Resolution Center falls, and to which the judge was appointed in 2011. In his capacity as Chief Executive Officer of QNB, Mr. Al-Ahmadi had personally threatened my colleagues in his office in Doha in November 2007 and demanded that I withdraw the proceedings referred to above. And then, if I can ask you to go on, please, to page 702. He directly refers to the evidence from the respondent about the judge and the Qatar court. I do not accept this is paragraph 68 of the affidavit, I do not accept Mr. Penna's summary of my case in this appeal, which is a matter of law. I will answer only his evidence where it consists of facts that I dispute. Mr. Al-Ahmadi, I do not understand Mr. Penna to dispute that Mr. Al-Ahmadi was personally involved in the affairs of the company before and after the liquidation, but rather he disputes that he held a position of authority in the Qatar government at the relevant time, including as Minister of Finance, to which post Mr. Penna points out that Mr. Al-Ahmadi was appointed in April 2013. In fact, it was June, I think. Mr. Penna exhibits Mr. Al-Ahmadi's details at page 10 of MP4. The short CV at page 10 of MP4 makes clear that Mr. Al-Ahmadi was also a member of the Supreme Council for Economic Affairs and Investment, one of the petitioners, and was the group chief executive of the Qatar National Bank since 2005. This means that he was at the heart of the Qatari government. The previous Minister of Finance was his father-in-law and a close blood relative by blood and marriage, Youssef Hussein Kassar. In fact, that should be Kamal. A copy of an article about Mr. Al-Ahmadi published in GSN, the Gulf States newsletter, on the 4th of July 2013 is exhibited here too at page 1 of WA3, the exhibit. Mr. Penn's statement that Mr. Al-Ahmadi's position of influence within the Qatari government is not supported by the facts is untrue, and indeed the reverse of the true position. And I'd ask you to go to that exhibit because it deals with Mr. Kamal's position. You'll see it's what was described. It's an article.
Right, where is the exhibit? What page?
It's page 708. And it says, Qatar's new finance minister, Ali Sharif Al-Ahmadi, faces a daunting task of bringing discipline to a public sector that has become bloated and inefficient, etc., and refers to deliver on its huge infrastructure projects in time for the 2022 World Cup. He brings valuable experience to the table, having been chief executive officer of the bank for 8 years. And then there's some information given about that. Then the next paragraph, QNB's success has been closely linked to its relationship with the state, which owns 50% of its stock. The bank's domestic business model is largely based on receiving deposits from the state and state-backed companies with one hand and lending back to them with the other. In this endeavor, Ahmadi worked closely with former finance minister Youssef Hussein Kamal, a close relative by blood and marriage and ally who supported his rise to the top of QNB. As Minister of Finance, Ahmadi's relationship with the bank is likely to continue, as he is expected to take Kamal's position as QNB chairman. He has also been appointed to the board of the Qatar Investment Authority and already sits on the board of something else. Almazeedi joined QNB in 1998, and there's some further material. Then, according to a 2005 leaked US diplomatic cable, he was implicated in a scandal but voluntarily handed over his proceeds. The cable also noted that despite support from Kamal, the central bank governor at the time, opposed confirming Almazeedi as chief executive in the light of the scandal. It was not until after the change in governor that his role was finally confirmed. His appointment as Kamal's successor at the Ministry of Finance, while logical, was not a foregone conclusion. A well-informed cabinet list that circulated in Doha a few weeks before the transition correctly identified some key elements of the cabinet that put a different name in finance. Perhaps if I could just read part from the last paragraph. It is illustrative of the fluid and opaque nature of Qatari politics, a world in which Almazeedi is a skilled operator. Rumoured to succeed Almazeedi is the chief business Al-Kuwari, and says that Mr. Almazeedi may miss his days at QNB, a smaller ship, but one that was more responsive to his hand on the tiller. My Lord, that refers not only to Mr. Almazeedi, of course, but also to his relationship with Mr. Kamal. Mr. Kamal was the Minister of Finance at the time that this case began in the Cayman Islands. Mr. Kamal was also not only the Minister of Finance, but he also had been involved in the disputes with the appellant. My Lord, it is important because this again was important to the Court of Appeal's conclusion in relation to Mr. Almazeedi. Lord, I can ask you please to go to the third volume of documents, which is the petition documents, the sixth affidavit of Mr. Almazeedi, which was sworn on the 25th of January 2012. My Lords may recall from the...
What's the NS reference?
It's at page... it starts at page 1472.
1427, I think.
No, my Lord, I
No?
don't think so.
No.
Sixth affidavit?
Sorry, quite right. Yep.
You may recall that this affidavit is referred to by the Court of Appeal as having been sworn long before any question of the judge's independence or apparent bias could have arisen. But the relevant passage is at 1475. It's perhaps worth pointing out that this affidavit was actually sworn the day before the winding up order was made. In paragraph 4, he says, I fulfilled my fiduciary obligations to the company and to all of its preference shareholders. And then he gives some examples of that. And at little d, he says, I eliminated Qatar National Bank's ability to undermine the assets of the company by replacing its letter of credit facility with a cash collateral order. And e, I placed certain executives of the petitioner and the Qatar National Bank on notice by submitting memoranda dated March 21st, 2011 and October the 17th, 2009, respectively, to each of their respective boards, clearly citing their respective institutions' conflicts of interest and the actions that had undermined and threatened to further undermine the company's assets. And my Lord, just before going to the relevant exhibit, can I just ask you to note, so we don't need to go back to it later on, paragraph 8, which is the allegation involving intimidation, which the Court of Appeal referred to. The petitioner has engaged in intimidation. Page 1477. The petitioner has engaged in intimidation tactics. Most notable was a bizarre and very lengthy one-way exchange on a flight from Grand Cayman to Miami on December the 8th, 2011, in which Andrew Long made QIA's internal legal counsel threatened me in full view of fellow passengers to retaliate against me and the company's lawyers for daring to stand up against the state of Qatar. This was followed by personal threats to my colleague, advising him he should protect his family by resigning immediately from his position as an executive manager. Just to put that in context in the chronology, that flight would have been immediately after the judge had made the order in relation to the validation proceedings.
And then 9, shall we read?
Yes. Well, my lords, I don't think it's going to be necessary to consider the allegations made by the parties in the petitions, but it is...
I wasn't suggesting that, no.
No, but it is something which I know my client would wish me to emphasize, that throughout allegations have been made against him. They are completely denied. I don't believe that they're relevant to your lordship's consideration
I didn't mean to imply that they were. I simply was alighting on the reason why the company was consenting to the order.
Yes. Well, once the validation process was, as he put it, sidelined, there really was nowhere for him to go.
Well, can you explain the legal connection between the validation proceedings and the winding up petition? The winding up petition was on the basis that relations between the shareholders had irretrievably broken down, or the relationship between the constitutors of the company. Now, as I understand it, it was agreed among all of the people with the economic interest, namely the preference shareholders, that they had broken down. Is that correct?
Yes.
Well, now, on that footing, on what basis could the judge have refrained from ordering it to be wound up?
Well, my lord, if the preceding events had gone differently, in which he was involved, then the consent would not have been, the position would have been different.
But why does that logically follow? I mean, I understand...
Well, I don't say that it necessarily logically follows, but as a matter of fact, it was only after the judge's, in my client's words, sidelining of the validation application that he consented to the petition.
Well, I understand that subjectively his evidence is that the one thing led to the other. But I would simply like to know whether there is any objective basis for that.
Well, one is dealing with the events which occurred.
Well, I mean, you may be absolutely right in saying that the answer to my question is irrelevant.
Yes.
But I would still like to know what it is.
Well, my lord, I think all I can say is that if circumstances had been different, there had been another judge, there had been a different outcome to the validation proceedings, a different report, that the events which took place on the 26th of January, I think it was when the order was made, might not have taken place.
Well, I'd just like to understand why that is so. I mean, either relations between these parties had broken down or it had not. Why would a person who has lost the validation proceedings or seen the validation proceedings treated in the way that they were, why would that lead a reasonable person to take the view that the relations had not broken down? What's the connection between the two issues objectively? Is there any?
Yes, because if the validation proceedings had permitted the asset swap transfer to go ahead, then it would not have been necessary for the company to go into liquidation.
Well, the reason it was necessary for the company to go into liquidation was that relations between the corporators had broken down.
But if
as a result, as I understand it, of a history that went back a long way before this transaction.
Well, one can't speculate as to precisely what would have happened. And the answer to your question, my lord, which we will come to in slightly more detail later on, I think, is that it is indeed irrelevant because that if the judge should not have been sitting in the court in the first place...
I quite understand your submission about that, but at the moment I am puzzled as to what the objective connection is. You may find it possible to diminish my puzzlement in the course of your address, but I'd like you to know that I,
Lord, let's hope
am
so.
sceptical about this.
Well, I understand what your lordship is putting to me, and I'll come back to it if I may. Well, my lord, I was going to come on to the demonstration that Mr. Kamal was every bit as, or not every bit as, but also involved in the transactions as was Mr. Almazeedi. And that involves, Lord, looking, I've taken you to the paragraph, but going on to look at the exhibit, which is at page 1487. And you'll see that that is a letter written by my client to Mr. Kamal, who at that time was both Minister of Finance and Chairman of the Board of the Qatar National Bank. And it's subheaded. It's written to a number of other people, as you'll see, all of whom associate in one way or another.
Well, it's written to all the directors by the look of it.
Yes, yeah. And it said conflicts of interest involving a senior Qatar National Bank executive. And, Lord, it's a long letter, I won't read it all, but the point is really a simple one. He says on page 1488, the second paragraph, I've been advised to file a complaint with the banking regulators. I do not attribute a deterioration of relationship to QNB as an institution. I attribute it to Mr. Almazeedi, who is causing his subordinates to act adversely, not only against my firm, but also against the interests of my firm's anchor investor, the QIA, and the bank. And then he deals on page 1489 with the problems in considerable detail, but I don't think I need read any more of that page. Well, the letter concludes on page 1490. I must consider my ultimate responsibility, which is to protect the investment of my shareholders, including the investment of the bank. These actions by Mr. Almazeedi and his subordinates under his direction have undermined my ability to do so. Unless the situation is resolved promptly, I will be forced to pursue other remedies. I cannot and will not accept attempts to imperil my investment under my firm's management. And he asks the board to assign a new team. But, the letter was addressed to Mr. Kamal. It was also responded to by Mr. Kamal, and we have his response, which is at the first page of the supplemental bundle, page 1501 electronically. Writes, Dear Mr. Almazeedi, I refer to your letter to the board. Extremely surprised and disappointed, it's a well-known formula, to have received your letter. Particularly disappointing to receive such a letter in circumstances where my management team have been engaged in discussions with you concerning QNB's exit from its investment in the BTU companies. And then last paragraph, finally, for the avoidance of doubt, please take note that QNB fully reserves its right to take any legal action required to protect its reputation and interests in relation to any wrongful allegations made against it and its officers. And then signed by Mr. Kamal, and then you'll see CC at the foot of the page, copied to Mr. Almazeedi. On the basis of that material, all of which, save the last letter, were before the Court of Appeal, and the last letter could have been put before them. It's not a challenge document in any way. The same point upon which they decided to to set aside the orders after Mr. Almazeedi's appointment could have been applied with equal force at the outset, because Mr. Kamal, who was occupying the relevant position at that point, was also involved in the litigation with Mr. Almazeedi at that time. So, my Lord, that is the point we make on the first aspect of the appellant's argument, that really applying the same logic as the Court of Appeal, had this been drawn to the judge's attention, no doubt he would have recused himself, but in any event, it means that the orders which were made from the very outset must be set aside, not just those made after the appointment of Mr. Almazeedi.
I think at one point in his case, Mr. Tregear refers to the Qatar National Bank, QNB, as being a petitioner. I think he was probably a supporter. That may not matter. Is it right that of the preference shares, QNB held 8%?
I'm afraid I'd have to check.
Well, don't bother.
I'm afraid I'd have to check.
If that's wrong,
But
it'll,
I mean,
it'll be
I think that...
I think it was 7%, and I can't tell you where
Well, there we
I
are.
found that.
I think
Well,
the
I could see-
petition asserts that 93% is said to have been held by the petitioners and supporting preference shareholders, and I think that the other 7% was QNB.
Well, my Lord,
What page is that?
it probably doesn't matter that it's just QNB, because these people, as we can see from the background material, don't simply occupy one position. They appear in Mr. Kamal's case and Mr. Almazeedi's case to be involved with really certainly more than one, and in often cases virtually all of the government agencies which are in the background here, and supporting preference agencies. I've taken you to the article which talks about the opaque nature of the Qatari setup. And one of the points that I'm going to make in a moment is that it's somewhat artificial to divide Mr. Almazeedi and others from Qatar as a whole, and indeed that is exactly the way in which the threat was put to my client on the aeroplane, which has never been denied, that he would, catch it if he carried on opposing Qatar. But that's
Thank you.
that's the position. Lord, as I've said, quite apart from this point, the appeal is also put on a somewhat wider basis. And Lord, I wonder if it would be convenient if at this point I was to take you to the authorities. There are not very many of them, and I don't propose to take a great deal of time over them because I think they're well known. But it may be just as well to look again at the matters of principle which we have.
How far are they summarised in your case or referred?
Well, I've done my best, but Lord, obviously,
Can we use that as a...
I think we're enjoined not to put chunks of authorities in our written cases. So
I think you are, yes.
But I mean, Lord, I'm hoping that this is not going to take me outside my allotted span. Lord, just first of all, perhaps we ought to remind ourselves that the Constitution of the Cayman Islands is in effect in exactly the same terms as Article 6, which is, of course, what was being considered in English cases. In other words, it guarantees to persons in the Cayman a fair hearing before an independent and impartial court. Lord, Article 6, the Constitution, for anybody's note, is at tab 2, page 1688. Article 6 is at tab 3, page 1691. And if I can go to Millar and Dixon, my Lord, that's at tab 19. Again, I know your lordships will remember that this is the case about the temporary Scottish judicial appointments. If I can go to paragraph 41, first of all, in the judgment of Lord Hope.
Sorry, we're going to tab.
It's tab 19 of the authorities bundle. Thank you. Page 2041, if you're looking electronically, but paragraph 41, central to the rule of law in a modern democratic society is the principle that the judiciary must be and must be seen to be independent of the executive. And then there's a quote from Lord Fraser of Tully Belton's book, security of tenure is the more vulnerable to erosion at the hands of the executive. I apologize, that's a very fundamental observation, which I know hardly needs authority, but if I can then go on, please, to paragraph 52. The right which a person has under Article 6 of the Convention to a hearing by an independent and impartial tribunal is fundamental to his right to a fair trial. Just as the right to a fair trial is incapable of being modified or restricted in the public interest, so too the right to an independent and impartial tribunal is an absolute right. The independence and impartiality of the tribunal is an essential element if the trial is to satisfy the overriding requirement of fairness. The remedy of appeal to a higher court is an imperfect safeguard. Many aspects of a decision taken at first instance, such as decisions on the credibility of witnesses or the exercise of judgment in matters which are at the discretion of the presiding judge, are incapable of being reviewed effectively on appeal, as Lord Stayne said in Brown and Stott. It is a basic premise of the convention system that only an entirely neutral, impartial and independent judiciary can carry out the primary task of securing and enforcing convention rights. Of course, the same observations apply if one substitutes the Constitution of the Cayman Islands for the convention.
That's an absolute principle. I mean, supposing you had a decision which was absolutely inevitable and which didn't depend upon assessment of witnesses or indeed assessment of anything. It might be taken by a judge who was an inappropriate judge because of apparent bias, but couldn't the appellate process cure the position in that context?
The appellate process?
Yes, I mean, here they're saying it's no good with going to appeal because you can't effectively review many decisions on appeal, well, especially if they depend on the judge's, first instance judge's evaluation. But what if that isn't the case? What if, in fact, on appeal, you have a decision which can be seen to have been inevitable?
No, the principle is such that the safeguard has to be absolute. That is what the authorities say.
Yes, well,
respectfully,
is there a clear example of that?
Well, Lord, the case of Yakub is quite a good example of it, which I know my Lord and
yes.
Lord Hughes were involved in. We'll look at it a little later on. But the fact is that the principle is such that it can't admit of any compromise. And the authorities repeat that. Even the authority which most argument was about, Prince Geoffrey, says exactly the same thing.
But I'm not sure Yakub is. You see, Yakub was about the constitution of the court, which was selected by, as it turned out, more or less accidentally, but it turned out that it was that the constitution of a court to hear an appeal from the first instance judge was selected by the first instance judge. It wasn't a question of whether any order that the Court of Appeal made was inevitable. Supposing, for example, in the case of the temporary sheriffs, just let's assume for the sake of argument that the Scottish procedure is sufficiently like ours for the example to hold. Supposing that at a preliminary case management hearing in front of a temporary sheriff, there were a consent application to amend the indictment, which the sheriff acceded to, the temporary sheriff acceded to, and then the trial in due course proceeds in front of somebody else. Are the proceedings all null and void?
Yes, they are.
You say they are?
Yes, they are, because, I mean, it's not very different, my Lord, to the position of the man who pleads guilty.
Well, it is, you see, because it's extremely different. The man who pleads guilty has still to be sentenced.
But his plea of guilt has to be recorded.
Yes.
And that is inevitable.
I see.
I mean, the fact is that you either have an absolute principle or you don't. But you can't, and the authorities suggest it's an absolute principle.
I see.
Obviously one can look around for an authority which is on the point, and perhaps you'll be thinking about that.
Yes. Well, we'll see what the authority says in a moment.
this
about
does
this,
say
but one has to look absolutely.
Yes,
This authority says it's an absolute principle. It also says that one has to look at the position at the outset.
Well, what the use of the word absolute in that context is to contrast it with being solved by a remedy of appeal, which clearly isn't sufficient for the reasons that Lord Hope gives.
Yeah.
There is a different question, or at least there might be, there may not be, but there might be a different question about orders which are so inevitable as not to involve any effective judicial decision-making at all, such as, for example, the amendment of an indictment by consent.
Well, let us say that the plea of guilty was entered in front of a temporary judge who adjourned it off to a permanent judge.
Yes.
But it would still be on the authority, something which could not take place because.
I follow.
But that in I think on your lordship's example would be an example of inevitable. The court doing something inevitable without any consideration.
Yes, might be.
But it would have to be set aside in our submission.
I see.
I mean, that's because of the principles which have been explained. And there's every good reason why they should be absolute, because if your lordship were to make an inroad on them, there's then...
Where does it stop? Where does it stop?
Where does the inroad stop and start, and when does it apply?
I see.
But, my lord, I was going to go on to paragraph 62 in the same report. The essential point on which this is the Lord Advocate, the Solicitor General, based his main argument was the question as to whether the Lord Advocate was unlawful had to be tested at the date when the challenge was made. This had to be done in the light of all the facts and circumstances which were known to exist at that time. All there was in this case was a perception that the temporary sheriffs lacked independence, but the reality was that they did not lack independence. In fact, their judgment was unaffected, and there were no grounds for saying that the verdicts of guilty were unsafe or the sentences imposed were excessive. The appellants were unable to show that they would derive any real benefit from being retried or sentenced again. He invited us to hold that the decisive factor in these cases was not that the right to an independent and impartial judge had been waived, because no plea and bar of trial had been taken at the outset, but that the use of temporary sheriffs in these cases made no difference, in fact, to the result. In my opinion, this argument overlooks the fundamental importance of the convention right to an independent and impartial tribunal. These two concepts are closely linked, and the appearance of independence and impartiality is just as important as the question whether these qualities exist in fact. Justice must not only be done, it must be seen to be done. The function of the convention right is not only to secure that the tribunal is free from any actual personal bias or prejudice, it requires this matter to be viewed objectively. The aim is to exclude any legitimate doubt as to the tribunal's independence and impartiality. Yeah. And then there's a reference. And well, that really answers my Lord's question.
Well, I'm not sure it does, actually, Mr. Guthrie. If, as you said, in drawing attention to the Sir Bernard's judgment in this case, the point about unconscious bias or apparent bias is the danger of unconscious effect. Then if there is simply no risk of unconscious effect, it is possible, at least, that the position might be different.
No, but my Lord, the point that I was making is that the purpose of the principle is to exclude any legitimate doubt as to the tribunal's impartiality.
I know exactly how you put it, Mr. Guthrie.
And that goes back to the point when the judge is assigned to the case, as we'll see picked up later on in the same judgment.
Look at the end of paragraph 63, which is perhaps the point you should just, last two paragraphs, last two sentences.
Yes, it is a question which, at least in the case of perceived impartiality, stands apart from any questions that may be raised about the character, quality, or effect of any decisions which he takes or acts which he performs in the proceedings.
To be judged, Lord Clerk said, from the very moment when the judge or tribunal becomes first seized. So you go into court, and at that stage, you don't know whether the judge is going to raise points of his own motion and whether there maybe objections.
But if this is translated to our position, you have to look at the point when the judge, Mr. Justice Cresswell, is assigned to the case in the Cayman Islands. And I propose to do that in a moment. My Lord, I also I think, yes, it's really that passage on page 2487 to 2048 I wanted to take you to. It probably doesn't help very much for me to read it out now. It'll just take up time. It's in front of your lordships. But perhaps I should look at paragraph 65. The principle of the common law on which these cases depend is the need to preserve public confidence in the administration of justice. It is no answer for the judge to say that he is in fact impartial, that he abided by his judicial oath and there was a fair trial. The administration of justice must be preserved from any suspicion that a judge lacks independence or that he is not impartial. If there are grounds which would be sufficient to create in the mind of a reasonable man a doubt about the judge's impartiality, the inevitable result is that the judge is disqualified from taking any further part in the case. No further investigation is necessary, and any decisions he may have made cannot stand. One really sees how strong the principle established by that case is. And it shouldn't, in our respectful submission, be watered down in any way. But Lord, the next case, of course, is the famous Porter and McGill case. But Lord, I don't think it's necessary to look at very much of it. It's paragraphs 87 and 88, which are on page 2188. Again, it's a judgment of Lord Hope's. Paragraph 87. The protections which Article 6 lays down are that, etc. As I shall explain later when dealing with delay, I consider that this sentence creates a number of rights which, although closely related, can and should be considered separately. The rights to a fair hearing, to a public hearing, and to a hearing within a reasonable time are separate and distinct rights from the right to a hearing before an independent and impartial tribunal established by law. This means that a complaint that one of these rights was breached cannot be answered by showing that the other rights were not breached. Although the overriding question is whether there was a fair trial, it is no answer to a complaint that the tribunal was not independent or was not impartial to show that it conducted a fair hearing within a reasonable time and that the hearing took place in public. See Miller and Dixon, and my own observations in that case. There is a close relationship between the concept of independence and that of impartiality. Then there's a quote from the European case, Finlay in the United Kingdom. And then the summary, the foot of paragraph 88. In both cases, the concept requires not only that the tribunal must be truly independent and free from actual bias, proof of which is likely to be very difficult, but also that it must not appear in the objective sense to lack these essential qualities. Lords, I think it's the well-known test is set out at paragraphs 102 to 103. I just note that, in fact, there is some consideration of how it's arrived at, but the test itself is at the last sentence on page 2194 of the bundle. The question is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. And then, if I could just read part of 104, there are 2 points that need to be made at the outset. The first relates to the auditor's own assertion that he was not biased. And then I would agree that the reasons that he gave were relevant, but an examination of them shows that they consisted largely of assertions that he was unbiased. Looking at the matter from the standpoint of the fair-minded and informed observer, protestations of that kind are unlikely to be helpful. But Lord, I will refer, I think, back to that at a slightly later stage. But it's quite clear, as we've already seen, that as a matter of law, the test has to be applied when the judge first became seized of the case. We say that quite apart from the Almazeedi or His Excellency Mr. Kamal point, there were sufficient reasons in the present case to mean that the test was met at the outset of the present case. Lord, if our first point is right, then that's enough in itself. But even if we were wrong about that, we say that the circumstances in the present case were such as to have really caused concern on the part of the notional observer in the Porter and McGill sense.
Sorry, can you just, I know you did move to a wider canvas at some point, but could you just identify how you put the first point differently from the wider point?
Well, simply on the basis of the Court of Appeal's judgment, in effect, because the Court of Appeal said, if you like, just to treat the matter in a very summary way, they said that we think that the appointment of Almazeedi was so egregious that the involvement of Mr. Almazeedi was so...
Send that back to Mr. Kamal, but then the wider point is...
The wider point is that...
the same point looked at more widely.
Well, it's the same point looked at more widely, yeah. But the same point would exist if your lordships were to, so to speak, obviously you won't, but were to sort of put Mr. Kamal on one side for the moment. In other words, there are a number of other factors.
And Mr. Almazeedi?
Sorry?
And Mr. Almazeedi?
Well,
I don't...
it's a slightly artificial exercise, but I do want to draw your lordship's attention to a number of matters which we say should have led to the same result.
Are you saying then, Mr. Guthrie, that even without Mr. Kamal having been the Minister of Finance at the beginning, and even without Mr. Almazeedi having been the Minister of Finance towards the end, there was enough here to raise the spectre of apparent bias?
Well, I would say that, but because of the way matters have developed, it's rather...
artificial.
It is somewhat artificial, but I do think I need...
Well, I mean, your wider point seems simply to have led into an examination of the legal authorities, and that's why I was puzzled.
Well, the reason I went to the examination...
was.
The reason I went to the legal authorities was because I was going to link them to the other matters. Yeah. But, Lord, I don't want to... if I've taken things in slightly wrong order...
How you put the case.
Yes. Well, I hope I've made it clear. I've told you the argument based on Mr. Kamal, and to say that the Court of Appeal, if they had known that, would have decided the matter differently, because they would have decided all of the orders must be set aside and not just those after Mr. Almazeedi's appointment. But the wider point is that if they had... I perhaps am putting this in a misleading way. We would have appealed, I put it like this, on the basis of their decision, even if I hadn't been able to deploy Mr. Kamal. Does that make it clear? Because we say that the circumstances...
well, because you say that even without Mr. Kamal and possibly even without Mr. Almazeedi's, nonetheless, this is such a Qatari event that, what, is that the point?
Well, that's the point, although, I mean, I'm not critical, but I don't think your lordship quite does the argument justice by saying this is such a Qatari event.
You say it's such a Qatari crusade.
Well, it's not just a Qatari crusade. The circumstances of the judge having the two appointments, and the fact that the Qataris were so, the executive was so involved in the court and the proceedings, taking all those circumstances together, that it was illogical to draw the line where the Court of Appeal did. They ought to have looked at the outset and said, even at the outset, before Mr. Almazeedi's appointment, the circumstances were such that a reasonable observer would have concluded there was a likelihood of unconscious bias. So, my Lord, in order to do that, there's one more authority which I ought to take you to, which deals with the attributes of the notional observer, which obviously one has to consider, because the court is putting itself, if you like, in the position of the notional observer in deciding what
Is this wonderful passage in Lord Hope's judgment in Hello?
No, it could be, but I was going to be as economical as I could and take you really to the Belize Bank case, which I think really draws a number of the threads together. And you'll find it under divider 7. It's paragraphs 34 to 39, which refer to a number of the authorities. Paragraph 34 refers to the test itself, Porter and McGill. The fact that 35, it's been followed by the Privy Council in the Cayman Islands case, and in Prince Geoffrey, which anybody need to come back for. The notional observer must be presumed to have two characteristics: full knowledge of the material facts and fair-mindedness. Applying these qualities to his consideration of the issue, he must ask himself whether there is a real possibility that the decision-maker would be biased. In considering how the notional observer would approach this task, one should recall Lord Steyne's approval in Loyal and Northern Spirit of Mr. Justice Kirby's comment in Johnson & Johnson that a reasonable member of the public is neither complacent nor unduly sensitive or suspicious. On the question of the state of knowledge that the fair-minded observer should be presumed to have, Lord Hope said in Gillis, the fair-minded and observant observer can be assumed to have access to all the facts that are capable of being known by members of the public generally, bearing in mind that it is the appearance that these facts give rise to that matters, not what is in the mind of the particular judge or tribunal member who is under scrutiny. Of course, one needs to be alert to the danger of transforming the observer from his essential condition of disinterested yet informed neutrality to that of someone who, by dint of his engagement in the system that has generated the challenge, has acquired something of an insider's status. This theme was taken up by Baroness Hale in Gillies when she said at 39, the fair-minded and informed observer is probably not an insider, i.e. a member of the same tribunal system. Otherwise, she would run the risk of having the insider's blinders to the faults that outsiders can so easily see. But she is informed, she knows the relevant facts, and she is fair-minded. She is, as Mr. Justice Kirby put it, neither complacent nor unduly sensitive or suspicious. Or perhaps I should have said this is Lord Kerr speaking in this judgment. It might be supposed that if the observer is provided with a surfeit of information, his or her detached status would be affected, and the essential component of public confidence in the lack of bias in the decision-making process would be imperiled. One can understand that it is necessary that the objectivity of the notional observer should not be compromised by being drawn too deeply into a familiarity with the procedures, if that would make him or her too ready to overlook an appearance of bias. But I do not consider that either Lord Hope or Lady Hale were suggesting that the amount of information available to the observer should necessarily be restricted to that which was instantly available to a member of the public. The phrase capable of being known from Lord Hope's formulation holds the key, in my opinion. This does not signify a need to restrict the material to that which is immediately in the public domain. It acknowledges that the observer must have such information as may be necessary for an informed member of the public without any particular specialized knowledge or experience to make a dispassionate judgment. As Lord Bingham put it in the Prince Geoffrey case, the requirement that the observer be informed means that he does not come to the matter as a stranger or complete outsider. He must be taken to have a reasonable grasp of how things are usually done. My Lord, with that in mind, can I suggest that the matter can be approached from the point of view of looking to see whether this is how things are usually done, and indeed by posing a similar question to that posed by my Lord Hughes in the Yaqub judgment, saying that that surely cannot be right. If I can digress just on the question of Yaqub at the moment, which I wasn't proposing to read in detail because I know it'll be familiar to you, but for the record, it's a divider 15, page 2324. The facts of that case were different, as Lord Hughes already pointed out. But one thing they do is demonstrate how absolute the principle is to be applied. Lord, I was in that case representing the Crown and trying to sort of hang on to the judgment of the appeal court. And I had thought that I was on a reasonably good wicket. But the decision that was set aside was a decision which had been reached by 3 senior English circuit judges, all of whom was accepted were of the highest integrity, and against whom, so far as the decision concerned, no error of any sort was alleged. It was the fact that the presider of those 3, who had nominated the other 2, had himself been nominated by the senior circuit judge who'd heard the case at first instance, meant that the position was that they were tainted by apparent bias. And that meant that they could not be considered to be an independent and impartial tribunal, and their decision had to be set aside. So, my lords, it does demonstrate that there is an absolute principle. My Lord, if one looks to see the considerations which would have been confronting the informed and fair-minded observer in the present case, I have summarized in my written case, which I'll give you the reference to. It's at page 1630. But the documents, your lordships, will find in the second volume at page 2258. If I can then say that the page references in my written case aren't quite the same as the ones I'm going to give you now. Now, information being capable of known by the public generally, first of all, one has to look at the circumstances of the assignment of Sir Peter Cresswell to the present case and what the observer would know. My Lord, certainly they would know that he was a retired English High Court judge, and as I've always said in this case, that would be something which they assumed in his favour. But as we've seen from the authorities, it can't be overestimated, and it can't in any case be decisive. It's no answer to say that the judge is a man of unimpeached integrity, or that he was not in fact biased, or that his decision was right. And we've looked at the authorities which come to that conclusion.
Well, I mean, it's clearly right that that is not an answer to an allegation of apparent bias. But is the status of the judge nonetheless one of the factors that the hypothetical, fair-minded and informed observer would bear in mind in deciding whether there was a risk of bias?
Yes, indeed. It may be. And the best example of that is the Prince Geoffrey case, which, if I can just, without taking you to it, remind you, involved the Sultan of Brunei's brother. And the challenge was made.
A Hong Kong judge who was described as being at the end of his career and so on.
Yes, exactly. And it being, but the challenge in that case was one of actual bias. It was also a challenge not only to the retired Chief Justice who was hearing the case, but to every judge of the High Court of Brunei. It was suggested that the matter simply couldn't fairly be tried at all. And as Lord Bingham pointed out, in Brunei, the Chief Justice had the same security of tenure, indeed slightly greater security of tenure than some judges do in England. And it was with all those matters, so to speak, being taken in the mix, that the unimpeachable quality of the Chief Justice, so to speak, swung the day in the.
I mean, it's one factor. It's not more than.
It's one factor. It's not more than one factor, and it's not a decisive factor.
Not at all.
And I think
the point also, I think, made by 2 members of the House of Lords in Hello and Secretary of State for Home Department.
Yes, I mean, I think there's the well-known passage that judges are known to be human.
It's Lord Roger and Lord Mance who made that point.
Yes, and I think also one has to perhaps bear in mind that judges are not immune from criticism, and one should be very careful about overemphasizing the respect.
Well, and also, I think there's been quite a lot of writing about decision-making generally, and it's actually a rather frightening vulnerability to subjective factors, including things like what you've most recently been talking about, which can have completely irrelevant impact on if you go into court, apparently. But,
well, Lord, that wasn't one of the points I was going to make.
It's very interesting to read some of the academic study of decision-making generally, and it's not specifically related to judges, obviously. It's more general. But subconscious influence is much larger than we think.
Well, Lord, I can only agree with that. Well, one's looking to see what, in this case, the notional observer would know. And the first thing he would know would be that Sir Peter Cresswell is a retired High Court judge of unimpeachable reputation, and that, well, I really considered it. I'm simply saying that, with the greatest of respect to him, it's not decisive, and it shouldn't be overestimated when one considers all the factors concerned. Well, the observer would also know that he was one of the members of the Cayman Court, the Financial Services Division. The details about the court are set out in the documents and were before the Court of Appeal. They're at Volume 2, at pages 258 to 271. But what I don't think I need to take up time by taking you to it. There are 6 judges, 3 full-time and 3 part-time, which would presumably indicate to the notional observer that the 3 part-time ones are available to sit.
6 judges, 3 full-time, 3 part-time.
3 part-time. And presumably the fact that some of them are part-time would indicate to the observer that those 3 were available to sit if circumstances require. It's not clear from any information that I've been able to discover whether that is simply when the workload for the 3 full-timers becomes too great, or whether they may be seconded in if there's some particular case which is thought to be suitable for them, which sometimes happens, of course, we know. In fact, there's no publicly available information as to the reason for any particular assignment of any particular judge to any particular case. The FSD, the Financial Services Division Guide, is included in the bundle at divider 4. And all it says is that the registrar, it's at page 1694. And all it says at item 6 is that the registrar, acting in consultation with the Chief Justice, shall assign every financial services proceeding to one of the FSD judges, and the cause number assigned to it in accordance with Order 5 shall include the judge's initials. One can't derive any particular reason why any particular judge should arrive to any particular case, but there's all that that is apparent really is that there are a number of part-time judges available to hear cases.
But is there any complaint about the process within the Caymans? I thought the complaint was about the judges' other.
No, the complaint is not about the process within the Caymans. The question is what the observer knows about the assignment of the judge. And what he knows from the Cayman end is that he's a part-timer who's assigned to this particular case. And there's no particular reason why he should have been. That's all that the observer's going to know.
Right.
And indeed, as far as I can tell, it's all an insider such as myself would be able to find out.
What's the position about de-assignment? You assign a case and put the cause number, put the judge's initials with the cause number. Does this imply that the Chief Justice could reassign a case, or presumably if a judge couldn't continue to act, he could then?
Well, it's speculation, but presumably that
yes, I think it must be
some way it'd be fine to deal with it. But the notional observer would know that this case was combined to this case to this judge when the winding up petition was issued, which was on the 11th of November, and he would know that the judge had very recently become a member of the Qatar Commercial Court, although apparently he hadn't yet been sworn in. He would presumably have thought this was rather unusual. And I say that because it obviously is rather unusual to find a judge in the Cayman Islands with no obvious links to Qatar. I mean, there are no obvious links between the Cayman Islands and Qatar, being assigned to a case involving Qatari interests when he is the only judge on the island with any links to Qatar at all. One has to remind oneself that the National Observer is not an insider. He's not going to be particularly familiar with the judicial arrangements. But he's going to think, well, hang on a minute, why on earth of all these judges is the one with the link to Qatar dealing with this case? And there isn't an answer, save to say, well, it's an unhappy accident. And I don't think that is an answer, because we can't rule out. It did occur to me at some stage that it might have been thought that, oh, well, we've got a Qatari case, we've got a Qatari judge, might be quite a good idea for him to deal with it. But I mean, there's no evidence about all this. And I should make the point here that there's absolutely no objection generally to external appointments of members of the judiciary. This I've set out for purposes of a note in my case at page 1630, paragraph 23, Roman 3. But this case actually gives an example of quite how widespread this is. Sir Bernard Ricks has an external appointment in Singapore. Sir George Newman has external appointments not only in the Cayman Islands but also in the Bahamas, or he did at that time. I think he's no longer sitting there. Mr. Motley has appointments in the Cayman Islands, Belize, the Turks and Caicos, and Barbados. As we know, Sir John Chadwick, who was the president of the Cayman Islands Court of Appeal at the time, had an appointment in Dubai. He did recuse himself. Lord, I won't take time by looking at that in any detail, but what happened was that when I...
it's in your case. So.
It's in my case. I just was going to tell you that his reasons for recusing himself were that he thought it would be an unfortunate overlay on the appeal.
You don't have two disputes.
Yeah, well, exactly. But it is perhaps important to note that I had written a letter saying that I didn't want, although it was unfortunate, I was going to have to refer to this on my first occasion ever appearing in the Cayman Islands Court of Appeal, ask the President to so to speak, pirouette away. But before we got to that stage, he came into court and said there was something he wished to say, and he explained in great detail his appointment in Dubai, as a result of which my objection to his sitting became slightly strengthened. I'll just give you the reference to that. He explained his position at page 842 to 848.
842?
To 848. And at 846, perhaps it is worth just looking at this very quickly. It's towards the end of part 2. Having explained at some length what his appointment was and how it had come about in Dubai, he said, in those circumstances, I should not sit on this application without first inquiring whether either party has an objection to my doing so. It is necessary that if there is such an objection, it should be made public and should be supported by some reason.
So what page was that? That was
846 to 7. Well, of course, this is really what we say Sir Peter Cresswell ought to have done when he came into court on the first occasion. He should have said, the parties ought to be aware that I'm a member.
He could hardly fail to do so, given that...
I'm sorry?
He could hardly fail to do this, given the nature of the dispute which had by then arisen.
Yes. Well, that's certainly true. But we would say that it is really the only area of express criticism that we make of Mr. Justice Cresswell is that he didn't refer to his appointment when he came into court. Now, the subject of the case is another matter which the notional observer must be assumed to have known about. Lord, I've already indicated the extent that Qatari government interests are involved. Well, one would assume that those were facts within the notional observer's compass. Also, the facts about the Qatari court. In summary, the Court of Appeal put it, in the Qatari court, the power of appointment of the judges and the removal of judges is confided to a senior government minister, who is himself, in this case, involved in the dispute between the parties. Now, that is something which it must be assumed the notional observer would know. My Lord, I don't want to go to details but unnecessarily, but shall I just tell you that the law number 7, which is the law which confides the control of the Qatari Dispute Resolution Centre to the minister, is tab 5, which is at page 1695. It's also exhibited to Mr. Almazeedi's affidavit, and the reference to that is volume 2, page 281. The observer would therefore know that the executive has a control over the Qatari court, which he does have, and he would be able to contrast that with the position in the Cayman Islands, where the judge's security of tenure is secured by Section 96 of the Constitution. Well, Section 96 of the Constitution, for the note, is at tab 2, page 1689. But your lordships will be aware that in order for a judge of the Cayman Islands to be relieved of his or her position,
yes, it has to come to us ultimately.
Well, not only would it have to come to you, but it's quite a lengthy and detailed procedure. And indeed, I think my Lord Mance has personal experience of it, because we had a case. I've included it. It's not relevant otherwise than to mention it. It's under tab 13, where a judge in the Cayman Islands, unfortunately, was subjected to this procedure. And indeed, at the end of the day, it was thought right that her position should be considered by a 7-member board of the Judicial Committee. That is what happened. But if I can just observe that is what is thought to be necessary to protect the security of tenure of judges in the Cayman Islands. And it has no comparison with the Qatari situation. We think it is necessary and nothing less is necessary, and that it is necessary to guarantee the fact and the appearance of judicial independence. Well, surely that is a matter that the notional observer ought to be assumed to take into account. You'd say, why is there a judge trying this case whose position in Qatar is less protected than what my country has guaranteed to it by its constitution? I just remind your lordships of that passage in the decision in Miller and Dixon in Lord Hope's judgment at paragraph 41, where he talks about security of tenure as being one of the 2 pillars of judicial independence, and the one which is the more vulnerable to encroachment by the executive. Now, that protection is achieved in Cayman, but it is not achieved to the same extent in Qatar. And in the Prince Geoffrey case, as I've already indicated, I can give you the page reference. I know my time is not unlimited. Is at 1935, where Lord Bingham points out that the Chief Justice was protected in Brunei by security of tenure. That no doubt an important matter which we say that the notional observer should take into account, should be assumed to take into account. It's also fair just to say briefly, he or she may have something less than absolute faith in Qatari judicial independence. The reason I feel able to say that without, so to speak, being too going too far is that it's only what the UN Special Rapporteur said in relation to the judicial system in Qatar, and the document making that good is in your Lordship's bundle 2. It was exhibited to Mr. Almazeedi's affidavit at page 277.
You've set it down, haven't you? In your case again.
Well, the important paragraph is at the top of page 278.
Right.
Where it says, it's rather difficult to read, I'm afraid, while any direct interference is extremely difficult to document.
What line is this?
It's the very top of the page, and I apologize for the quality of the copy. While any direct information is extremely difficult to document, reports of interference of the executive in the work of the judiciary, particularly in cases involving high-level persons, are still a matter of concern.
I'm sorry, which page are you reading?
Page 278.
Thank you very much.
At the very top. Furthermore, the independence of judges, in particular their security of tenure, might be jeopardized by the provisions that allow for dismissal of judges on vague grounds relating to public interest. While such provisions might not have been invoked recently, they remain problematic. So, my Lord, if...
What's the first line say? The constitutional provisions relating to the separation of powers do not seem to be...
I'm sorry,
something.
Lord, I just got on to the next reference. I'll come back to it.
Seem to be... Is implemented?
Fully implemented?
Well, Lord...
yeah, maybe fully implemented, yeah.
Yes, I think yes.
Yes.
Yes, I think it
Right.
is fully implemented. So, my Lord, if the informed observer would know that the Qatari justice is not necessarily spotless, and as I say, he'd be entertaining the same doubts. And indeed, the Court of Appeal in the present case, and the references in paragraph 95, page 31, said that it was not possible to say that interference in Qatar was unknown. And I don't want, obviously, to press the point too far, but the informed observer, a notional observer who is who might be excused, put it no stronger than that, for thinking that there is a possible question mark of a corrupt nature over Qatar, bearing in mind, as it happens, more or less at the time this case began, there had been the recent allocation of the World Cup to Qatar. One may say one's going a bit too far, but if the National Observer took that into account, he'd only be echoing the headlines of newspapers all over the world. So I'll leave it at that.
You're not going to make a submission as to which newspapers are the independent?
No, Lord, no. But I don't know the National Observer has to be attributed, has to be attached to any particular newspaper. But all I'm saying is that it would. I've said it in my case. The fact is, we're dealing with Qatar, which does not have perhaps the reputation for absolute integrity that some countries might have. So, Lord, it is the possibility of interference by the executive which the observer might wish to take into account, and we would submit that it can't be ruled out, that the National Observer would think, even leaving personalities out of it, that the situation was hardly ideal, finding a judge of the Qatari court in the Cayman dealing with that. But Lord, you have the point. Lord, I would add this. The National Observer were perfectly entitled to take into account the fact that the judge hadn't mentioned the fact that he had a Qatari connection. And I've already taken...
What would you conclude from that?
Well, Lord, why not? I mean, it's a... the learning, if I can just summarize it without... I don't think it's contentious in any way, is that if there is a reasonable question, the judge should raise it. He certainly shouldn't raise some footling objection simply for the sake of
Except
it.
there are two possible constructions one might put on it. One is that it never occurred to him that this was a source of apparent bias. The other is that it was, and he wished to conceal it. But I mean, those two. It's wholly ambiguous, isn't it?
Well, exactly, but it's most unsatisfactory that these things should be left in the air at all.
Well, it's usually put the other way around, but if you mention these things, that's a sign of transparency and openness and lack of potential bias, and makes the hurdle more difficult to cross.
Well, it also gives the parties the opportunity of drawing any relevant matters to the judge's mind, which is an important consideration in this case. But, my Lord, we do actually, rather unusually in this case, do have something of an insight. It's most unsatisfactory how this came about into the judge's position, because you may have picked up that there was a really most uncalled for,
Yes, the Chief Justice.
Yes. Well, I mean, it's a matter that we did complain about, and we do still complain about it.
I personally haven't actually looked at that material. Should we? Are you inviting us?
Well, it does have some relevance to. I mean, it certainly is not dispositive of the appeal, but one of the unsatisfactory features of this case is that I was going to touch on fairly briefly. It does, as I say, it's not dispositive of the appeal.
Can you give me the
yes.
page?
Absolutely.
Is this point in your case, actually?
Yes, it is.
There's a passing reference to it, certainly. You do want us to look at it.
Well, I think you should.
No, that's up to you.
I think you should look at it. Lord, it's the reason I was just finish what I was saying to my Lord Mance. The fact is that the Chief Justice is still involved with this case.
Right.
And
yes, we've seen that. It's giving rise to problems.
It's given rise to a considerable number of problems. But I think it's perhaps important, since it happened, for your worship to know about it. I wrote a letter. I'm sorry.
Well, presumably, on the Court of Appeal's order, everything that the Chief Justice is now doing is going to be set aside.
Exactly.
So that's.
Well, sorry.
If it isn't.
No, if I win the appeal, it'll be set aside.
I said on the Court of Appeal's order. Yeah. If you.
No.
If you resist the cross appeal.
No. I see.
Winding up order is set aside.
I'm sorry. No.
I see. So
at the moment, the liquidators are proceeding as though the Court of Appeal.
I see. So you'd have to win the first part before
Yes.
the Chief Justice's current activity was affected. It wouldn't be sufficient to hold the Court of Appeal's order.
But if there's no winding up, because the winding up order is set aside,
yes.
frankly, it doesn't matter what the Chief Justice may have done or said at any stage.
No, because it'll all disappear in a puff of smoke.
Yeah. So the Chief Justice is not building on anything which Mr. Justice Creswell did after the date identified by the Court of Appeal.
No,
Except
but
he is making orders in a current way.
he is making orders, but
say
there
it's
is.
invalid.
Well, perhaps it would save time if I just go to the. If I tell you, at volume 2, page 893.
Page 893.
Yes. The judge wrote a letter. And he said, being concerned as Chief Justice, this came after the hearing and before the judgment, being concerned as Chief Justice about the assertions made by Mr. Almazeedi, alleging bias and lack of independence on the part of Justice Creswell, I raised the matter with the judge. Following his response, and then there's some words in inverted commas, in italics, this is what he said. And then the judge went on, the parties have an obligation to place accurate information before the court. Failure to have done so in the past is no basis for allowing the court to continue to be misled. Any statement in a judgment should be accurate as to Mr. Justice Creswell's involvement with Qatar. Well, we did feel that was quite wrong, because apart from anything else, I was rather cross that the parties have been accused of misleading the Court of Appeal, which I don't think there's any reasonable basis for supposing they were misled. But it's a most unsatisfactory letter, because we have no idea at all how the matter was put to Mr. Justice Creswell by the judge.
I think I'm right in saying that all of the statements made in the letter from Sir Peter Cresswell are in evidence
Yes.
in one shape or another in the material.
Yes, effectively that's right.
So there's nothing in there that is...
Well,
I mean, I'm not doubting that this is a surprising letter to have written, but the actual contents did not introduce any new factual
well, I think there might have
case.
been something which was effectively not important, which they hadn't known before. I think we didn't know, for example, that he hadn't met any member of the Qatari government. But I mean, so what really? I mean, the fact is that, if you like, we were content when we were told that the Court of Appeal didn't think that any harm had been done by this, and my client was content with that. But of course, the judge doesn't say why he didn't disclose his appointment, or whether he would have recused himself if an application had been made to him to do so. And it doesn't actually deal with the details of the appellant's case on the appeal at all. But we do think it was an attempt, or appears to have been an attempt to, not by the judge, because we don't know how it was put to him, but by the Chief Justice to intervene in the appeal. My Lord, I have included in the bundle a case which my Lord Wilson decided when he was in the Court of Appeal, called Brissett and Brissett, in which a civil exchange had taken place between a district judge and a circuit judge in relation to an appeal from the district judge. And it was said it was no less than a permission to the district judge to take part in the appeal from his own decision, which effectively is what this was. And it's not just unfortunate, and we've said that we're perfectly content that the Court of Appeal's assurance that no harm had been done. But the fact is that, say, the Chief Justice has continued to make orders adverse to Mr. Almazeedi since writing this letter, and we consider that to be absolutely wrong.
Can we just get clear after you, please?
I was wondering what this had to do with the present appeal.
Well, it has nothing to do with the decision of the present appeal, save us to this. Whatever happens in the future is going to be speculation, but we would very much like it spelled out that whatever happens in the future should not involve the Chief Justice in deciding the case. Because he did... I appreciate my time is very short, and I don't want
I think you overrun.
I think I've overrun, and I apologise for that. But in the supplemental bundle, your lordships will find a number of documents. Unfortunately, not the... I'm not going to take you through them because I think that would be outstaying my welcome. But first of all, Solomon Harris, who was representing the appellant of the Cayman Islands, then the appellant himself, because he was unable to carry on paying for his lawyers, made the point to the judge that he shouldn't be hearing this case any longer because he'd been involved in various earlier stages of it, and he had committed this, as we say, wrong action in writing to the Court of Appeal before the judgment and putting this material before it. He delivered a short ruling, which unfortunately is not in the bundle, but should be. It's attached to a letter at, I think, page 150. 150, forgive me.
I mean, I'm again, I don't want to stop you necessarily, indeed I'm going to ask a question now. The Chief Justice's activity appears to be included hearing an appeal against the rejection of the proofs of debts,
Yes.
but the proofs of debts were only withdrawn or rejected after the date which the Court of Appeal took as the critical date, in other words, 26th of June 2013. So presumably if the Mr. Justice Creswell's rejection of the proofs of debts is vulnerable, there won't be any basis on which to uphold the Chief Justice's rejection of an appeal.
If I succeed in the appeal, all of this will
well,
be...
of course, that's undermining the whole winding up order.
Yes.
Yeah.
My question relates to what Lord Mance has just said. Sir Peter Creswell had refused your client's appeal against the rejection of the debt.
Yes.
The Court of Appeal scrapped that because it came after the relevant date.
Yes.
The respondents seem to have been proceeding from the foot of the Court of Appeal's order in recent years by asking the Chief Justice to dismiss the appeal against the rejection of the proof of debt. And he's done that.
Yes, he has.
So my point was simply to get clear in my mind that the respondents have actually been proceeding upon the basis of the Court of Appeal's disposal.
Yes, they have.
Very well.
In fact, it's gone... the respondents have, as well, my client would say, been harassing him ever since this judgment, because they've introduced the supplemental bundle really deals with this. They've been application after application for costs, for orders ex parte, they've brought proceedings to the United States for discovery. They've recently, I think on November the 11th, although this is not in the bundle, they've started a fresh action against him in the Cayman Islands. All of these matters in the Cayman Islands are listed in front of the Chief Justice. And the Chief Justice...
Just one point following on from Lord Wilson. I followed everything he put to you up to the very end. In fact, are the respondents proceeding on the basis of the Court of Appeal decision? Aren't they proceeding on the opposite basis? Because
they're proceeding on the reject. They're proceeding on. The liquidators themselves rejected the proofs of debt, and they immediately, after the judgment of the Court of Appeal, invited the appellant to withdraw his appeals against their rejection of the proofs of debt. He refused to do that, so they went and got orders from the Chief Justice.
But if the rejection of debt's been set aside because Sir Peter Creswell was not eligible to adjudicate, why are either party taking any steps in relation to it?
Because they say that the position goes back to the as at June the 13th, or whatever the date was, the
26th of June 2013.
Yes, the position on that day was that the liquidators had rejected the proofs of debt, and there was an outstanding appeal, and it was the outstanding appeal that was set aside, not the liquidator's own rejection of the proofs of debt.
But it logically ought to be starting all over again. I mean, if the challenge to the rejection of the proofs of debt is entirely invalidated because it took place before an ineligible judge, then it ought to be now allowed to commence afresh.
I thought the analysis was your client appealed against the rejection.
Yes.
Sir Peter Creswell rejects your appeal.
Yes.
That his disposal is set aside.
Yes.
So there is now a revived, outstanding application by your client to appeal against rejection of the debt.
That's right. Yes.
And the Chief Justice dismisses it.
Yes.
Is that it?
Yes, and we say that the Chief Justice should not have been... the difficulty is my client, suggested that these proceedings have no practical benefit for him, by my learned friend. The fact is he's been ruined by these proceedings. He has been unable to do anything about them in the Cayman Islands. I mean, he's been able to pursue this appeal, but that's it. He's also...
Well, we really can't proceed on the basis he's been ruined by it.
Well, no, I mean, I'm not suggesting that...
I'm not suggesting that you should... You're touching on a point which I think arises on the cross-appeal, namely that you say that this was and remains, as the Court of Appeal found, throughout, even after the winding up petition, effectively a dispute between two camps.
Yes.
Whereas the other side say, no, at least from the winding up petition, it's nothing to do with that. There's objective appointed liquidators who are acting objectively, and you don't have any interest.
Well, my Lord, I don't know that I can really improve on the way in which the Court of Appeal dealt with that point.
Yeah.
And it's a paragraph 78 and 79 of the judgment, but as I say,
Right.
But that is the reality. We say that the overwhelming position is that Sir Peter Creswell ought not to have begun on this, and for the reasons that I've developed. Lord, I just because the document is missing from the bundle, I ought just to refer to it. The Chief Justice, when he was challenged as to his intervention, referred to it as being something he'd done in his administrative capacity as Chief Justice. I have copies of the ruling that he made ex parte in my client's absence, in fact, without any warning that he was going to give a ruling at all about
I think you fumbled for the reference before, Mr. Guthrie. What is
150?
150? And you
Well, it's
didn't know what the
1508.
fourth number was.
It's 1508.
But we can read it for ourselves.
Well, you can't, my Lord, because it's incomplete, and I can give you the balance of it. There are sufficient copies there, if it handed around. But you can certainly... it's just that... this is, as I say, you'll see from the correspondence that this was a ruling which we didn't know would be taking place and weren't there. And it's the second paragraph. The complaint raised in Solomon Harris' letter cannot, in my view, be reasonably objective sustained. Written in my administrative capacity as Chief Justice, which we consider in the circumstances to be somewhat weasel words. And then simply concerned to ensure that accurate information was placed before the Court of Appeal.
You say this ruling did not follow any submissions here?
Well, my learned friends instructing attorneys were there, we weren't, and I don't think we knew the hearing was even taking place.
How does that come about?
Well, Lord, without taking you through the supplemental bundle in detail, unfortunately, I mean, it's not a matter which your lordships can possibly decide, but we do have very strong and, in my estimation, justified objections to the way in which the Chief Justice has dealt with this matter.
The letter from Solomon Harris, which paragraph 1 of this ruling refers to, is no doubt in the supplemental bundle.
It is at page 1508, I think.
Or 1506.
1506.
1506 is
Yes,
what I thought it might be. Thank you very much. It's all right.
I hope that your lordships will have the opportunity of reading that. Lords, I think I've covered the ground that I intended to cover.
Thank you very much, Mr. Guthrie. Yes, Mr. Tregear.
My Lords, if I can deal with some of the matters which emerged just at the end of my learned friend's submissions, in particular in relation to the position of the joint official liquidators of BTU Power, and in the context of the documents which your lordships have just been shown. On the 18th of December, there was an application before the court, but it didn't relate to Mr. Almazeedi. It related to sanction for certain transactions which the joint official liquidators wished to take in the course of the liquidation of the company. So they're related to the sale of certain assets, and at that hearing, the Chief Justice was shown the letter from Solomon Harris, which is at 1506, and it was on the basis of being shown that letter and the representations being made to the Chief Justice that he should consider the contents of that letter before then going on to consider whether he could deal with the application, that he made the ruling, which your lordships have been handed up today, and that ruling was then sent by my instructing attorneys in the Cayman Islands on the 13th of January at page 1508. The application didn't concern Mr. Almazeedi, but the Lord Chief Justice's decision did take full account of the position of Mr. Almazeedi and whether the giving sanction to the proposed transaction in any way prejudiced his interests as a claimed creditor of the company. My Lords, going back to what the joint official liquidator's position is following the decision of the Court of Appeal in November 2015, it has been to proceed on the basis that they are duly constituted as the joint official liquidators of the company and to proceed with certain steps Some of those steps don't involve Mr. Almazeedi at all. They relate to how to deal with the liquidation of the company and how to manage the assets in the meantime. But to the extent that they related to the proof of debt appeals, my Lord Wilson's analysis is, in our respectful submission, completely correct. The position was that in the performance of their duties as joint official liquidators, they had rejected certain proofs of debt which were submitted by Mr. Almazeedi in his own capacity and then as owner and controller of a number of other companies. As we deal with it in our written case, the total of those proofs of debt was $40 million. Before a hearing before Mr. Justice Cresswell in January of 2014, about $20 million of those proofs of debt had been voluntarily withdrawn by Mr. Almazeedi. And by the time of the hearing before Mr. Justice Cresswell in January 2014, all that remained of the proofs of debt for Mr. Justice Cresswell to consider was a proof of debt of $672,000, which Mr. Almazeedi claimed to have spent in the course of litigation in Massachusetts. So, my lords, the sequence was that the joint official liquidators had rejected all the proofs of debt. Mr. Almazeedi had appealed within the time provided for by the insolvency rules. His appeal had then been heard by Mr. Justice Cresswell in the ordinary course of events, reduced as it was to $672,000 at the actual hearing. When the Court of Appeal delivered their judgment in November 2015, the effect of that was that Mr. Justice Cresswell's orders dismissing the appeals against the rejection of proof couldn't stand.
Yeah, so it had to start all over again.
So what they did was they asked Mr. Almazeedi to proceed with his appeals, because there is a time limit for appeals to be proceeded with. And in that process, they asked the court for an order in relation to those appeals, which is in the supplemental bundle at page 1525. And what they asked the court to order was to give security for costs in relation to the two extant proof of debt appeals, one by a company called BTU USA, and the other by Mr. Almazeedi individually. And they asked for an order that Mr. Almazeedi file and serve any evidence upon which he intends to rely in respect of those appeals. Those appeals were his appeals. And the Chief Justice made those orders at page 1525, and they were coupled with an unless order, which your Lordships can see from paragraph 2 on page 1526, that unless the former director had taken each of the steps set out above, they should be dismissed in their entirety. Mr. Almazeedi's position was that he was not going to participate. He didn't participate. And so those appeals were dismissed. The effect of this appeal, or what Mr. Almazeedi can and can't achieve on this appeal, is something which the joint official liquidators are keenly aware of. It is only if Mr. Almazeedi succeeds on the appeal against the judgment of the Cayman Islands Court of Appeal in effectively setting aside the winding up order, that the consequence will be that the joint official liquidators are not properly constituted, and so everything they have done will effectively fall away. But it would be wrong to think, as Mr. Almazeedi appears to, that the effect of the court's allowing his appeal would be to put the clock back to where it was in November 2011 when the petition started. It would be wrong to conclude that, because the constitution of the company provided that although the preference shareholders did not have voting shares in the company at all, the voting shares were held by another company controlled by Mr. Almazeedi, the articles provided that in the absence of a certain return on the investment in the life of the company, then the voting rights of the ordinary shares would lapse and the preference shares would become voting shares. The situation is now that the preference shares are voting shares.
Was that the situation at the time of the winding up petition?
It wasn't the situation at the time of the winding up petition, and that was why the petition was the only way the preference shareholders could exercise any control over what was happening in the company. There probably were the only other remedy the preference shareholders would have had in November 2011 might have been to bring derivative proceedings on the part of the company against Mr. Almazeedi.
Based on fraud?
Based effectively on a claim that the company has, which Mr. Almazeedi would suppress because he had control over the affairs of the company. And it's important in the context of the narrative which Mr. Guthrie puts before your lordships, not to paint the events of the life of the company with too broad a brush, because by the time the petition was presented, what the preference shareholders were complaining about had nothing to do with any earlier dispute about what had happened to fees paid to a placement agent. The complaints made in the petition all related to the management of the company. And the management of the company that was the subject of the complaint was the refusal of Mr. Almazeedi to provide financial information which the articles required should be provided, not to inform the preference shareholders about the asset swap, and that Mr. Almazeedi had, over the life of the company until 2011, not done what the articles required, which was to pay out dividends to the preference shareholders when the company was able to do that. And the fourth matter of complaint was that the company had accumulated significant income from its investments in the power plant in Tunis and the power plant in Abu Dhabi. But all that money had stayed in the company, and in fact all that money had been spent. And the petition was based purely on those matters, coupled with a general complaint that Mr. Almazeedi had become involved in litigation, not only involving litigation with the placement agent and his former co-director, but also litigation with former employees. And they were concerned that as sole director, his involvement in that litigation and the allegations that were being made affected their confidence in him. The position now that the preference shareholders have voting rights is that if the winding up order were to be set aside, the preference shareholders could all simply vote to put the company into voluntary liquidation under Section 99 of the Cayman Islands Companies Law. And they could then ratify all steps taken by the joint official liquidators in the course of the liquidation, except, of course, they couldn't ratify or make of no effect the judgments of the Chief Justice in relation to the proof of debt appeals. So they, constituted as voluntary liquidators, would then have to consider again the question of whether Mr. Almazeedi or his creature companies had any claims against the company, time having moved on, and maybe all sorts of other issues that arise, such as limitation. But the only advantage, if I can put it that way, that Mr. Almazeedi would derive from these proceedings is the limited advantage of being able, subject to limitation, to put a case that he was owed money by the company in voluntary liquidation, as distinct from the company in official liquidation.
That, on the face of it, is the $672,000, is it?
It is the $672,000.
It might, of course, be a different sum now, but
it's always possible other claims might be revived.
Yeah.
Because some claims fell away because the companies which were articulating them had been struck from the record. It's not inconceivable that they might be returned to the record.
Yes.
But essentially, the proof of debt, so far as Mr. Almazeedi personally is concerned, is $672,000. There is also a claim by BTU USA for $4 million, which has also been struck out. The Court of Appeal were concerned that in our submissions to them, we were trying to be over-formalistic about distinguishing between the company and Mr. Almazeedi, and it may be that we overstated that case, but we do submit, Your Lordships, that there is an important point as to what was in issue and between whom the issue arose at the time of the winding up petition.
Mr. Tregear,
Yes.
Is it a double-edged sword for you to say the only advantage to the appellant is the revival of his appeal against the rejection of the proof of debt? You could turn it round, I suppose, and say the only disadvantage to the shareholders is that.
Well, one could put it that way, but of course we're not really taking the initiative in this case. This is a case where we're not taking the initiative, and of course one says, as matters of, if I can put it this way, legal logic, that voluntary liquidators who are appointed after the winding up order is set aside can then ratify everything. One doesn't know quite what kind of cat's cradle one might get into with transactions involving third parties, but broadly, the company would go into liquidation. Mr. Almazeedi's position vis-à-vis the company would remain exactly the same as it always was. He has no economic interest in the company itself, but he has certain claims which at the moment stand at $672,000 in his individual capacity.
Is this in evidence, your scenario, if the winding order were now set aside? You said in particular that the preference shareholders now acquired voting rights and so on. Is all that in evidence?
My Lord, it follows from the articles.
Well, I thought there was some facts on which the basis of which it followed, namely failure to do something by the company to make profits or distribute dividends or what.
Can I first take Your Lordship to the articles?
Well, the articles simply say the voting rights are acquired if the distributed profits are below the
Yes.
threshold.
Well, the distributed profits...
we know it from the evidence whether they were. You've told us they weren't implicitly. Is that in evidence?
Can I come back to that point? I don't want to take time going through that question, but certainly that, on the premise that Article 64, the conditions are satisfied, then the winding up order would simply be replaced by a voluntary liquidation.
Well, that's what you tell us, and
Yes.
Then presumably there might be some advantages in the present proceedings. Haven't there been cost orders made against the appellants and so on?
Well, to the extent there have been cost orders made by Mr. Justice Cresswell, they've all been set aside. There have been cost orders made by the Chief Justice.
They have.
And they would also fall away.
There was no valid
if there was no valid winding up, because they're cost orders in favour of parties who aren't validly constituted as joint official liquidators. So there would be an advantage in that the liability to make those cost orders would cease. There has been no payment of any cost orders.
What would be the position about the liquidators' costs and their indemnity?
Well, that would be a matter which would almost certainly fall to be dealt with by the preference shareholders voting,
Right.
Because they would have control over the company and they would be able to make a determination as to how those costs should be dealt with, to the extent that they've been approved by the court in the course of a winding up, which was then set aside. Obviously, the liquidators couldn't rely on that, but it would be a question of going back to the preference shareholders and dealing with those matters. I think your lordships have Article 64, but just for the reference, it's on page 649.
649.
649, well, yes, I think. Oh, sorry, no, 369. These articles start at page 369, and Article 64.
Article 64, we went.
64, yes, on page 382.
Thank you.
provides that if the holders of preference shares haven't received during the first 10 years after the initial closing date, and that time has now passed, dividends or other distributions in the aggregate amount of at least the aggregate capital paid up on the preference shares with a return of 5% per annum, accruing without compounding on weighted average invested capital, and then there's something about calculation. Ordinary shares shall cease to confer on the holder thereof the right to receive notice of and attend and vote at any general meeting of the company, and the preference shares shall become voting shares, in which case the preference shares shall then confer on the holders thereof the right to receive notice of and vote at any general meeting, and then there's a provision made for how that vote should be carried out.
So it's not dependent on profits having been made, it's
dependent on distributions being received.
Correct.
Between the date of the liquidation, between the date of the closing date, which was I think in 2003.
2003. There might, I suppose, be a dispute about what distributions there have in fact been, but there are.
There might be, but certainly by the time of the winding up petition, and these figures are dealt with in our closing statement, our written case, the distributions to all members have been in the region of less than $1 million, and everything else had been spent by Mr. Almazeedi while he was the director of the company.
All right, well, this may or may not cut both ways. We ought to get to the central issues, oughtn't we?
Yes, just on our written case, what we say about distributions is set out there, and that's paragraph 29 of the written case. So your Lordship's are right. In a sense, it's a peripheral issue as to what is achieved by Mr. Almazeedi in this appeal, but we do respectfully submit that it's a matter of some importance to consider where the appeal goes, and the suggestion that Mr. Almazeedi can put the clock back is one which he can't make good. The other point which was made by my learned friend, Mr. Guthrie, just before he concluded, was that the petition proceedings had ruined Mr. Almazeedi, and that in some way it was all a consequence of the petition proceedings that he was now in the position he is in. In our respectful submission, that's to conflate Mr. Almazeedi's current position as a result of all sorts of events which have happened. And what actually happened on the petition was a petition to wind up a company in which Mr. Almazeedi had no economic interest. He had certainly certain contractual rights through the management company in terms of manager's fees. He had no economic interest. He received no director's fees. And so the winding up of the company didn't affect his economic interests in any way at all. To the extent that he had a claim for management fees, he could continue to make that management fee claim for as long as the contract which he had entitled him to such payments. But the other point in relation to the analysis of what the petition is doing is that the petition was a petition brought by the shareholders in relation to the company. Mr. Almazeedi, his only role in relation to the petition proceedings was until the very end, to give evidence on behalf of the company as its sole director. By the time the company had decided in early January, and he had put in his evidence in his fifth affidavit, which is in the petition proceedings, which is in part 3 of the petition documents, page 1465. He swore an affidavit on behalf of the company on the 25th of January, the day before the winding up order was made, in which he, at paragraph 10, page 1471, invited the court to make him a winding up order in the terms paid for paragraphs 1 to 9 of the petition. And on the same day, he put in the affidavit which your lordships were taken to by my learned friend at page 1472. And that affidavit was put in his own capacity, in which also he consented, at paragraph 9, to the making of the winding up order. And at the hearing of the petition on the 26th of January, the company was represented by Maples and Calder, and Mr. Almazeedi was separately represented by Mr. Nigel Meeson, QC, of Conyers Dill. And the learned judge, Mr. Justice Cresswell, sets out everything that was said to him before he made the winding up order on that date, and that's at page 87 in part 1. Pages 87 to 88, he records the appearances of Mr. Hyam and Mr. Gook for the petitioners. Counsel appeared for Dubai Islamic Bank. Mr. McImry and Mr. James Eldridge of Maples and Calder appeared for the company. Mr. Nigel Meeson appeared on behalf of Mr. Almazeedi, BTU Power Management Company, and QGen Limited, which was at that time the holder of the voting shares. And in recording the submissions that were made by counsel before him at page 92, the judge says, Mr. Hyam accepts, and I emphasize, that these allegations are untested and denied by Mr. Almazeedi. That's the allegations in the winding up petition. There is, however, as Mr. Hyam should be, rightly accepts, no need to address these allegations in view of the concession in paragraph 7 of the company's skeleton argument, that the company agrees that the relationship between the preference shareholders and the company has irretrievably broken down. And the company has indicated that it will not oppose the petition if that is what the preference shareholders and DIB desire. And then at page 94, Mr. Meeson, on behalf of Mr. Almazeedi, BTU Power Management, that's a manager, and QGen, emphasised that the court was invited to proceed on the basis that it was appropriate to make the order sought, given A, the 100% support of the preference shareholders, and B, the company's acceptance that it was inappropriate to oppose the petition. And he invited the court formally to record that the allegation in the petition that Mr. Almazeedi had breached various terms of the legal bargain between the company and its preference shareholders are untested and denied by Mr. Almazeedi, and there's no need to address those allegations, and the court doesn't do so. And then analysis and conclusion is on the basis of what had been said to the judge, understandably short. In all the circumstances of this matter described above, in the exercise of my discretion, I consider it appropriate to make a winding up order on the sole basis that the order sought has 100% support of the preference shareholders, and the company doesn't oppose an order on this basis. The company accepts that the relationship between the preference shareholders and the company, Mr. Almazeedi and BTU Power Management, has irretrievably broken down. So that was, obviously Mr. Almazeedi participated, but only in a very peripheral way. He participated right at the very end of the petition proceedings by putting an affidavit in his own capacity and on behalf of BTU Management and QGen, effectively accepting that there was no basis on which the winding up order could not be made. And my learned friend sought to submit that the position that was arrived at on the 26th of January was one that in some way all followed from the collapse of the asset swap agreement, in which your lordships were told that Mr. Almazeedi considered that the asset swap agreement had been sidelined by the judge, and in the passage quoted in my learned friend's written case, everything at that point was stacked against Mr. Almazeedi. In our respectful submission, two points fall to be made. Firstly, the asset swap validation order application wasn't sidelined. The asset swap was one of the matters that concerned the preference shareholders. And essentially what concerned the preference shareholders was that the scheme of the asset swap agreement was that whereas at the time of the petition, before the asset swap agreement, the company owned two assets. It owned 40% of one asset and 10% of another. It was going to swap its 10% in the Abu Dhabi plant with a company called Marubini's remaining 40% or 60% in the Tunis power plant. So the company would end up owning one asset, the power plant, and Marubini would have a bigger shareholding in the power plant in Abu Dhabi. Because there was a difference in the value of these two assets, there had to be a balancing payment made. And one of the things that concerned the preference shareholders, quite apart from the fact that the company was proposing effectively to go from two assets to one asset, was how much, in terms of the balancing payment, was going to be received by the company. And in order for the court to be able to consider the validation order, Mr. Justice Cresswell made an order, which your lordships can see at page 1265. And the order, 1263, my lords, is where the order starts. And it relates to the petition and to the validation application. And the company, as your lordships can see from the bottom of page 1263, undertook that it would appoint Deloitte to prepare a report on the proposed asset swap transaction and a fairness opinion, the fairness of the balancing payment being the subject of that opinion, and a current valuation of the company's interests in CPC, the Tunis plant, and TAPCO, the Abu Dhabi plant.
I understand it, the relevance of the validation of the swap agreement to the subsequent, to the petition, was that the circumstances in which the swap agreement had been made had, according to the petitioners, undermined their confidence and contributed to the breakdown of relations on which they were relying as a ground to wind up the company.
That was one of the matters the petitioners complained about, but one of the things they complained about in relation to it was they knew it was happening, but they had no detail or information about it.
But I mean, the relevance is that it was one of the grounds, one of the factors that had led to the breakdown.
Yes.
Which was the basis of the petition.
Yes. And the objective of the fairness opinion by Deloitte was to enable Mr. Almazeedi to make good or not make good his position, which was that the asset swap agreement was in the interest of the company and should go ahead, notwithstanding the presentation of the petition. And one of the points he made was that there was a time limit, or there was an expectation that the asset swap would, subject to an extension, be completed on the 22nd of December. In fact, that time was extended. And Deloitte did, they did produce a report, but the only report they were able to do, and the only report they undertook to do in a short space of time, was to consider the valuations which Mr. Almazeedi had got himself for the company, and to consider whether they were reasonable valuations, in order to effectively critique those valuations. But in the process of doing that work, where they said that the valuations Mr. Almazeedi had used were in principle reasonable, they had analysed the various values which had been achieved for the company, and they showed that whereas on the basis of the values Mr. Almazeedi had for the asset swap agreement, 87.5 million should have been paid to the company as a balancing payment, the asset swap being in relation to which validation was sought, only provided for 51.9 million. So as at that stage, there was clearly material on which the preference shareholders could be concerned that the asset swap was selling the company short. And those figures are on page 1320 from the Deloitte report. And your Lordships can see on the top of page 1320, Fieldstone was the valuer whose valuations Deloitte were critiquing, if I can put it that way. And they had a valuation in May 2008, which produced, on the basis of the relative values, a balancing payment of 77.3 million to be paid to the company. Nearly 2 years later, 87.5, and then they analysed the amended term sheet, which was what Mr. Almazeedi was putting forward as the asset swap for which he sought validation, 59.9 million. But that, my lords, was only the first stage of what Deloitte were going to do. They were going to go on to do a valuation exercise, and that was agreed, and they were retained by the company to do that. So for Mr. Almazeedi to suggest that in some way that Deloitte was imposed on him is, in our respectful submission, not entirely correct. But Mr. Almazeedi then brought the validation order application back to the court on the 22nd of December at a stage where all that had been done was that Deloitte had critiqued the earlier valuations. And what the learned judge did on that occasion, one can see at page 1411, he ordered that the proposed validation order be reviewed on the material before the court, and then gave directions for any further validation application to be listed before him, and giving a timetable for any such application. So to speak of the validation order application being sidelined, or the asset swap agreement being sidelined, in our respectful submission, is to adopt, for the purposes of how the fair-minded independent observer is going to look at the circumstances of this case, the viewpoint of Mr. Almazeedi. By the time the winding up order, or the hearing of the petition on the 26th of January 2012 was concerned, Mr. Almazeedi had obtained an extension for the asset swap agreement. He also said he had another purchaser for the assets of the company, but by that stage, preference shareholders, all 100% of the economic interest, wished for the company to be wound up, and it was wound up in the circumstances which I've taken your lordships to.
When you say, Mr. Tregear, that he'd obtained an extension for the asset,
I think the validation order was an agreement between the company and a company called Marubeni. There was a drop-dead date, I think, on the 22nd of December. And that was
purely contractual.
It was a contractual
deadline for
date,
completion.
yes.
Thank you.
Yes. And by the time the matter came back before the court in January, Mr. Almazeedi explained that he'd got that extension, but also he explained that there was another purchaser whom he couldn't disclose but might be interested in the assets. But
What in the event that that the conditions of the agreement with Marubeni were not met?
Yes. And at that stage, the preference shareholders took the course they did, and the company and Mr. Almazeedi recognised that in those circumstances, there was no opposition that could be put to the winding up order. So as at that stage, we would submit on that basis, it's impossible to say that the sidelining, which is not what happened, but what happened to the asset swap agreement, in some way caused Mr. Almazeedi to concede by the 26th of January that the winding up order was inevitable. The asset swap agreement wasn't going to prevent or preclude or make unnecessary a winding up order. The asset swap agreement was simply to allow the company to dispose of its property following the presentation of a winding up petition. The company would still remain, after the asset swap agreement, a company with one asset only and a whole lot of cash. And the reasons that the preference shareholders gave in their petition for being concerned about the management of the company would apply in that situation just as much.
I think he says at some point that he was depressed by the rejection of the proposed valuations, and I think he actually makes cast aspersions at Deloitte's as well as at your clients. But
what's your position on that? You just say there's no evidence to support that, or I mean, he does say it somewhere, doesn't he?
He does. In fact, my learned friend quotes it. I hope this is the passage your Lordship is referring to. At page 1640, at paragraph 52 of his written case. And this is what we would submit is revisionism on the part of Mr. Almazeedi. He's quoted there saying he would wish to state he's never accepted that the decisions and orders made in these proceedings have been correct or fair to me. Since December 2011, when I saw what I considered to be the judge's sidelining and rejection of the company's application for a validation order with regard to the asset swap transaction, I have felt that everything was stacked against me and in favour of the Qatar.
Sorry, what's the reference?
It's page 1640, my Lord. It's
Don't think it is.
paragraph 52 of the
52?
respondent's... Sorry, the appellant's written case. I'm sorry, I think I told you, Lordship.
In his case.
I apologise. And he then goes on to say that in some cases he was persuaded to consent to matters, including the liquidation of the company, when I didn't wish to, and in expectation of benefits which would supposedly accrue to me in the liquidation. However, my understanding is that in the context of my complaint as to the judge's position, it's unnecessary for me to go further into the details of the decisions and orders made. But as I understood my learned friend Mr. Guthrie's submissions, as a way of trying to avoid the inferences that might be drawn from the fact that the winding up order was made with the consent of the company and of Mr. Almazeedi, an attempt was being made to say, well, it was all up after the asset swap agreement, and it was the asset swap agreement where I was sidelined. Well, the asset swap agreement in relation to the validation order was always an application by the company, rather, as opposed to Mr. Almazeedi. The validation order was never, the door was never shut on it completely, but it was shut on it at the time that Mr. Almazeedi sought the court to make an order. He brought the validation order application back on the 22nd of December at a stage when the evidence that was before the court was the Deloitte report as far as it had gone. So, in our respectful submission, one, at the stage where one is looking at the winding up order, it is clear that it is a self-contained order made in circumstances where all the parties who were before the court consented to its making. They all agreed that circumstances justifying the making of a just and equitable winding up order existed. And the court made its decision on the basis of what was common ground between all the parties. So if one were looking at that stage, just for a moment, looking at the Article 7 of the Cayman Island Constitution, just for a moment, if one were looking there to see, well, was there a determination of Mr. Almazeedi's civil rights by an independent and impartial tribunal, one comes up first of all against the point that there was in fact no determination of any rights at that point. What the court did was what all the parties before the court wanted the court to do. But one also is faced by the conundrum that in fact the civil rights that were being determined by the winding up order were the civil rights as between the parties, the petitioners and the company. It's very hard if one were to imagine Mr. Almazeedi bringing a claim simply under Article 7, say, well, my civil rights were determined by a court that wasn't independent, wasn't impartial.
Well, what he says is that this was a struggle for control of the company between him and the preference shareholders, and that the winding up order effectively determined it.
Well, he says two things. He says, firstly, this was part of a very long history, which, I respectfully submit, is entirely incorrect. There are totally distinct phases.
Right.
But his control of the company was subject to the preference shareholder statutory rights. Yes. And when the preference shareholders exercised their statutory rights and were unanimous in exercising them, he recognised that there was no struggle to be had. What the winding up order was simply the expression of the statutory rights. It wasn't, the court had no ability to weigh up on the one hand whether the preference shareholders were entitled to an order or whether...
No, I understand the submission that it's inevitable, but it's certainly affecting Mr. Almazeedi's personal position, isn't it?
Well, it transferred his, if you like, his expectation of payment by the company into contractual rights against the company.
Well, all right.
So whatever rights he had in terms of payment from the company, either by way of debt or in any other respect, either on his capacity or in the capacity of other companies, those rights were not affected by the winding up order. They're simply translated into claims and liquidation.
Which would have been met in full if it was solvent.
Well, it is solvent.
Yes,
Yes,
well, I understand.
exactly, yes. Yes, if they'd been good claims. I was unconscious at the time.
Well, it probably is convenient moment. Can you just wait a moment? Yeah. Yes.
Well, we've got plenty of time, haven't we?
We have, my lord.
Yes. Right. Well, we'll resume then at 2 o'clock. Thank you very much indeed.